Good morning and welcome to the Tennessee Court of Appeals. We certainly appreciate both of you and your clients agreeing to participate in this Zoom oral argument. It is not what we would have preferred, but obviously with the conditions, we believe it to be the safest and most efficient way for us to carry on the judicial process, and we certainly appreciate y'all participating. We will conduct this hearing the same as if you were in the courtroom with us. Each side will receive 15 minutes to make its oral argument. If you're the appellant, you may reserve up to 5 minutes of rebuttal time, and I'm sure that the appellant has already worked that out with Mr. Hibner prior to the hearing. Your panel today consists of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Both of you are experienced practitioners. You know how the system works. And absent anything else, Mr. Hibner, I believe you can call this case, please.
Janieka Ellington versus Cajun Operating Company et al.
And we will hear from the appellant.
If it may please the court, my name is Daryl O'Neill, and I represent the appellant, Ms. Ellington, in this matter. And we're here today to respectfully request this court reverse the decision of the trial court. And we make that request for 3 reasons. Number 1, we believe that the trial court weighed evidence. Number 2, we believe the trial court erred in finding that Ms. Sprouse acted outside the scope of her employment. And number 3, the trial court erred when it considered facts that were not included in any party's statement of facts. Now, I know that the court has reviewed the record, so I'm not going to waste your time regurgitating what we put in the briefs. However, I'd like to make a few points. First, as this court knows, when you file a motion for summary judgment, the non-moving party has no duty until the moving party negates an essential element of the case. We submit that that was never done in this particular matter. Specifically, whether or not an employee is acting outside of the scope of their employment is a 4-pronged test. The first prong of that test, and it's conjunctive, it's a 4-pronged conjunctive test. And the way that test works is it of the kind he is employed to perform? In this particular record, there is no evidence on the first prong of that test, no evidence. So they didn't even meet the very first prong of that test. But then the second prong of the test is it occurs substantially within the authorized time and space and limits of the employee. We don't dispute, and there's no dispute on the fact that this manager was at work during working hours when this event took place. But the third prong is it actuated at least in part by purpose to serve the master? Here's the problem. There is no evidence in the record on that particular prong. And in fact, the evidence goes the other way. There's evidence in this record that this manager has never been trained on how to handle disputes in her restaurant. Undisputed fact. So that prong was not met. The last
let me ask you a question, Mr. O'Neill.
Yes, sir.
I want to make sure we're all on the same page here. There was an altercation that took place in the restaurant. Is that correct?
That is correct.
Okay. Then there was theoretically some break in the altercation.
I dispute that.
Okay.
And there's no facts to support that there was a break. That's a fact that was weighed and determined by the court, but there is no facts to say that there was a break.
Okay. Then the actual injury, did it take place inside the restaurant or outside the restaurant?
It took place in the parking lot. And I'm glad you asked that question, Judge. Here's the problem with that. We don't understand, and we don't know by the statement of fact is what is the manager's control, whether or not the parking lot is part of her control, whether or not the inside or the outside of the restaurant is part of her control. There's no evidence in the record. It's what is her purview of control. So because that's not clear in the record, you can't rule one way or another on that particular fact.
Do we know what kind of time lapsed between the period of time that your client left the restaurant, exited to the parking lot, and the time that the altercation that caused the injury occurred?
Again, the black robe be on fire, Your Honor. Here's the problem. We don't know that. There is no evidence in the record of that time break. See, that's a problem. Because we don't know whether or not, in fact, what was happening is whether or not my client was running out of a restaurant because she was running towards the grease. We don't know any of that stuff. That fact is not in the record. And so that becomes another issue of genuine issue material fact, because it's not in the record. The next part of that is of that four-pronged test, Your Honor, is if the force is intentionally used by the servant against another, the use of force is not expected by the master. Here's the problem. They have a policy on how to handle these types of conduct. In this particular scenario, what the evidence goes to show is that this manager was never trained on that policy. She never signed it. She never received it. She never knew anything of the problem of the policy. So the company believes that these types of situations are going to happen and that they believe that these managers should handle them a certain way. But in this scenario, that manager wasn't trained. That again becomes another disputed fact.
When you say the manager was not trained, is that what the manager said, what the company said? It's my understanding that the manager had some training,
right? But
what training are we talking about, and what training are you suggesting was needed?
Well, there is in the undisputed fact, there is a statement that the manager received some kind of safe training. We don't even know what that safe training is because that's not clear in the record. But what we do know is there is an undisputed fact that the manager never received training on this particular violence policy, on how to handle a hostile situation or how to diffuse a hostile situation. We know it's undisputed that the manager never received any training on that. And that potentially may have, alleviated this situation. My client may never got injured as a result of that. But here's the other part of that is the manager was hired based off a 2011 application. There was never an update on the application. So she was hired on an old application. Now,
Mr. O'Neill.
Yes, ma'am.
I want to go back to something for just a moment. What is the proof that we have in the record as to your client? At one point, your client is inside the restaurant and then your client is outside the restaurant, correct?
Correct.
What is the proof as to why your client or the nature of your client leaving the restaurant and going outside the restaurant? What proof is there on that specific issue?
Again, that's the problem, Your Honor. There is no proof. The only statement of fact is that that my client and her fiance or whoever was walked out the restaurant into the parking lot. That's all that's stated in the record. We don't know why, whether they were running, whether they were being chased, whether she was going. We don't know any of that stuff. We just know that they left the restaurant, and at some point she opened the door and threw grease on them. That's what we know. Okay, and the problem with that is we're talking a motion for summary judgment, Your Honor. And the question here is, first off, we have to make sure we know what is the manager's purview of control. Is she responsible for the parking lot? Is she responsible for the inside of the restaurant? Is she responsible? What is she responsible for? We don't know that because it's not in the record. So whether or not they were inside or outside the restaurant is a concern because we don't know what the manager's purview of control was.
Why is that important that we have to know whether she was responsible for the parking lot? Because I'm just curious, why is that important?
Well, what we're supposed to know, Your Honor, we can't remember, this is a motion for summary judgment. So what we need to know is what these undisputed facts are. And what we need to know is whether or not what the manager's roles, responsibilities, duties, what's expected of her, what's not expected of her. None of that's in the record. So the point of that
let me ask the question. Did did you assert, or was that an issue raised at the summary judgment hearing based upon the undisputed material facts that the manager is responsible for the parking lot? Or did opposing counsel assert that there was no responsibility for the parking lot? I'm trying to determine why this is material at this juncture.
It's not material at this juncture, Your Honor, because we don't have roles of responsibility. But the question, the appellee never asserted that the manager's responsibilities didn't extend to the parking lot. So that was never, that's another fact that was weighed, because there is nothing in the facts that says that once the people left the restaurant, that Churchy's management has no more responsibility for that. There's nothing in the record on that. So the answer to that question is it's unclear. And when we talk about a statement of undisputed facts, the facts have to walk away undisputed, and it can't be an alternative position on that. And that's what we potentially have here.
In your complaint, Mr. O'Neill, did you allege that the manager acted in compliance with the company's policy in going outside? Did you make that allegation?
We alleged that we didn't have it with specificity. And as the court knows, Rule 8 doesn't require us to have the specificity in there. We just basically identified that the manager, within the scope of her duties and responsibilities, the company failed to train this manager on her roles and responsibility. And as a result of that, that led to my client being injured. It's what's in the complaint.
Well, following up on what Judge Armstrong just asked, and I'm again just thinking this through. You asserted that at all times the manager was acting in the course and scope of her duty. I'm assuming.
Correct.
I'm assuming opposing counsel said, no, that's not correct. That there was this break. I'm assuming again, or there was at some point in time, the opposing or the manager stopped acting in the course and scope of her duty when she went outside. Who has that burden then to show that the manager duty or zone of responsibility, I guess for another way of saying it, continued?
I think that in the motion for summary judgment, Your Honor, it's the onus is on the moving party to establish that the manager was not acting within the scope of her responsibility. It's not our onus doesn't. There's no onus on the non-moving party until they negate this essential element of a case, and they didn't do that because, again, the scope of employment has a four-pronged test, and just the simple first prong was not met because there's no evidence in the record to identify what the manager's roles and responsibilities are. And as a result of that, that is the reason why, again, once this gets to the jury may say, 1, 2, or the manager was doing X, Y, and Z, or that this fight, wouldn't have been, that the manager was protecting herself. But we didn't get that. This is summary judgment, and that's inappropriate at this particular time. I'll respond to any other questions on rebuttal unless the court wants me to answer something right now.
Thank you. All right, we'll hear from opposing counsel.
Good morning, Your Honors, Mr. O'Neill. First, it's good to see everybody, and particularly Mr. O'Neill, since I haven't seen him in a while in Memphis due to COVID. I'd like to address the concept of what has been pled in this case. And at the time of this motion for summary judgment, the only claims that were against Cajun, which is Church's Chicken, was for negligent supervision, negligent hiring, and retention. Trial court found that the plaintiffs failed to bring any type of claim for negligent training, that they in fact waived it during the arguments of this matter, and that's reflected in the record. So the discussion of what training Ms. Sprouse received is kind of, in a way, kind of a rabbit hole, because we can get into that if you want. And there are statements of facts which are listed, which set out her role as a manager of a fried chicken restaurant. I don't think there's any argument that could possibly be made that throwing hot oil following a dispute with a customer is in any way part and parcel of one's role as a manager of any restaurant at all that we've ever been to ever worked at before college or law school in any way. So the argument that training is at issue, I think, is kind of a moot point. The other issue that the court has in front of it is whether or not the claims of vicarious liability have even been brought in this case. Again, I read to the court what the allegations were made in this case. We've addressed vicarious liability because it takes us into the concept and into the issue of whether or not Ms. Sprouse was acting in the course and scope of her employment. And again, we're talking about throwing oil on a customer following a physical dispute within the restaurant. And Judge Stafford brought up the issue of the break. The trial court focused in on that issue. And I think it's interesting that the statement of facts that we put out in the course of our motion are identical in almost every respect, if not every respect, to those that produced by the plaintiffs. There are very few disputed facts. Those that were disputed that are referenced in our pleadings, which is part of the record, we didn't think was material. The things that the plaintiff brought up in the context of Ms. Sprouse's Facebook pages or a charge of domestic violence, all those things which go to the issue of whether or not Cajun is liable because of negligent hiring. It's our position and the court's position below that those issues weren't material. Churches did 2 background checks during the course of Ms. Sprouse's employment at various dates, because she came, then she left, she returned. Both of those times and all of those times, she came back with a clear record. There was nothing to indicate any type of problems or propensity of violence, anything like that, to put Cajuns on notice that Ms. Sprouse was some type of a problem employee or that this issue could happen. I liked the case that plaintiff provided us, Tyus versus Pugh, as an example of what is not supportable or what would not be supported of a motion for summary judgment in a trial court case. The difference in that case, of course, is that Mr. Bingham, the violent employee, had a long history of violence. He had violence at the workplace. The people that worked there knew of his violence in high school. They knew of ongoing issues throughout his career, which became the fact issue for the reversal of that case. That is not the case here. Ms. Sprouse was convicted. I can't recall, quite frankly, whether she pled guilty or was convicted. I believe she was convicted of assault. She received diversion. The statute that controls that option, if you will, for somebody who is charged with as she was, is only available if there is nothing in her history, nothing in her past to show any problems. So we want to talk about the prongs of whether somebody is acting or negligent hiring. I'm kind of jumping around a little bit, primarily because they're so intertwined, I think. I think that alone is enough to support the court's granting of the motion on that issue. The second issue we have really gets into, we can talk about the prongs, but I can't get past the idea that throwing oil on somebody is outside the course and scope of her employment. Judge Stafford broke up the idea of the break. I'm gonna get back to that for just a second. Frankly, whether I think there's a break or not, whether there's a wall or a window between the two is not necessarily dispositive. In the IHOP case that we have, the CRF, let me get the white reference. I apologize, it's the, can't read my own handwriting. The Morris versus Collins Foods, where the waitress threw something at a customer in the restaurant. And the trial court granted the motion for summary judgment. The Court of Appeals affirmed. Same basic facts. In this case, though, Ms. Sprouse had options. She had called 911 because of the confrontation between the plaintiff, Ms. Ellington, and her fiance. She could have locked the door between them. She could have done any number of things. But had she thrown the oil even in the restaurant, that would not have been, in my opinion, sufficient enough to reverse it. But those aren't the facts. The facts we do have is that she was outside the restaurant in some way or form or fashion. The statement of facts, again, are undisputed. These parties were leaving. Miss Ellington and her fiance were leaving the restaurant. Miss Ellington continued and accelerated the confrontation, physically picked up a hot substance, walked out the door and threw it. I can't imagine this.
I think you mean Ms. Sprouse.
Ms. Sprouse, I apologize. This is a unique, it's weird to look at myself as I'm arguing. I'm not a big fan of that at all, I'll be honest with you. But that break is a break. She followed the protocols up until that point. And you can be in the element of your employment. I can be working as a lawyer, but if I do something, assault somebody, do something, violent or something outside of what I do as in my job, then that's the break. We've got cases, and the cases are interesting, that deal with this type of issue because it deals with employees who are making kind of unilateral decisions that are independent of the company. You've got the gentleman at IHOP who decides on his own time away from the premises to leave and assault a customer. Obviously not within the course and scope. You've got cases that were cited, Fletcher versus, well, that's the Fletchers versus CFRA, the Bowers versus Potts, where employees have company cars, but then take it on a different path, if you will, and do a tort. And in one case, a wrongful death motor vehicle accident. That's outside the course and scope, even if they've been provided a vehicle. So the issue of whether or not Ms. Sprouse was acting in the course and scope, I can't imagine is much of a difficult leap for this court to make, given the actions that were taken. It is a question of law for the court to determine. When there aren't any disputes, material disputes of fact, and I disagree with Mr. O'Neill on that point, there is proof in the record to substantiate the role that Ms. Sprouse had, to establish the timeline of events. I don't think it's material whether Ms. Ellington and her fiance were running to their car. The fact is they were outside when it happened. There had been enough time that had passed for the issues to come up. Honestly, I don't think it's that complicated an issue. There's no way, again, that we can consider her to be within the course and scope. Unless the court has any questions, I'll concede back to Mr. O'Neill.
Seeing none, we will hear Mr. O'Neill in rebuttal then.
Thank you, Your Honor. Let me address first what Judge Armstrong said to me in the very beginning here, and that's this. Was this in your complaint? I'm looking at the complaint. Our complaint specifically states it has a negligence claim in it. And the negligent supervision, the complaint specifically states, Janieka Ellington suffered both mental and physical injuries as a result of verbal and physical abuse she suffered at Church's Chicken. Church's Chicken knew or should have known that Tamara Sprouse had a propensity toward violence and had in fact committed and threatened to commit several violent acts. The defendant had reasonable foreseen and anticipated that Ms. Sprouse would act violently. That's in the complaint. Negligent hiring and retention in the complaint. Suffered both mental. Janieka Ellington suffered these injuries because Tamika Sprouse was hired to manage Church's Chicken despite previous evidence of violence and or emotional abusive behavior. That's in the complaint for negligent hiring and supervision, negligent hires and retention. Those elements are in the complaint. In regards to what the appellee states about the cases, here's the distinguishing fact for each and every one of those cases. Let's talk about them. There was
Mr. O'Neill, before you get into that, I did have a question. The defendant filed the motion for summary judgment with their proposed undisputed material facts. Did you file any response disputing those facts?
No, Your Honor. What was done was there was an additional set of undisputed facts. There were two sets of undisputed facts. The defendant filed theirs and we filed ours. And
so rather than responding, you just filed a separate set. Is that what I'm understanding?
We filed a separate set of undisputed facts. And in that, and there is no, and I've challenged this court to find there is no fact that was out there that establishes what the roles and responsibilities. There is no fact at all in the statement of facts. But when we talk about these three cases that they identified, the Cracker Barrel case, the distinguishing fact on all three of these cases were the company had a policy. That policy was signed and received by the employee. In this particular case, that policy that the company has for how to deal with violent situation is not signed, it's not received. And in fact, the undisputed testimony in this record is the employee never received training on how to deal with these situations. And as a result, they don't meet the 4 prongs of what's considered the scope of employment. And as a result, that by itself should have got us at least to the jury. Subject to your questions, I thank you for your time.
Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and endeavor to get you a written opinion adjudicating it at the earliest possible time. We want to thank Mr. Hivner, Mr. Morgan from the AOC for making this technologically possible, since speaking for myself, I couldn't do it, but we appreciate y'all participating. And having said that, Mr. Hivner, if you'll recess court until the call of the docket this afternoon.
This honorable court is now in recess until 1 p.m.
Thank you.
Thank you, Counsel.